You're watching HQ Mornings, your mornings made informative on home quarantine. Our top stories for today. Local manufacturer receives a complaint after selling defective face masks.
Fans comfort Troyan Belisario regarding her dog's infertility.
Multi-million-dollar red car found to have interior defects.
Famous actress tries online product, gets face burnt.
Good morning, I'm Hans Sison.
And I'm RJ Blanes, and you're still watching HQ Mornings. It's a great morning to be in the country today, don't you think, Hans?
Absolutely, RJ. Let's begin the show with our first sizzling issue. Miss Natasha is an accountant from BPI Cebu. She is the co-host of hit show Investing Big and Smart. She's in the show now not to share her expertise but to present her case.
Let us welcome our first caller for the day, Natasha Bourbon.
Hello, Sir Hans, Sir RJ. Please, help me to bring justice to this bag. This good-for-nothing bag. Oh wait, no. Help me first to bring justice to the scammer, Bag Madness.
Okay, ma'am, please calm down a bit. We have on the other line the director of the company in question, Ma'am Carla Cabatania. Good morning, Ma'am Carla. We have here on the line Ma'am Natasha, who is reporting that you scammed her.
Good morning, Sir Hans and Sir RJ. And what do you mean I scammed her? I gave her what she wanted.
I wanted and paid for an authentic Chanel, not some second-rate imitation.
Ma'am, please don't insult us. Bag Madness is a sophisticated shop that's well known for its top quality products. I can guarantee you that we only provide 100% genuine...
Genuine? Did you hear her just now? How dare she call this loser bag genuine?
Ma'am, you're going way too far. That bag is made for fashion and delicate use. You only asked for the latest Chanel bag. And who would have thought that you would use it to carry heavy, hardcover books? And if that was the case in the first place, I would have just given you a tote bag.
Oh, so you're blaming me. You're blaming me for the disappointing quality of your product? Come on.
Ma'am, stop the nonsense. I can provide you, at this instance, the authenticity of our products.
I want a warrant. Sir Hans, Sir RJ, please help me bring justice.
Okay, Ma'am Natasha and Ma'am Carla. We have here on the show Attorney Denise Manliguez to enlighten us about this issue.
Good morning, Attorney Manliguez. Did you hear about Natasha's case just now?
Good morning to you two anchors. Yes, I heard the case crystal clear. It is interesting for sure. Article 1562 as well as the preceding articles of our Civil Code deals with this. We can only have two options when this happens. Either Bag Madness gives warranty or not.
Can you elaborate on that, attorney?
1. If during investigation it is found out that problem lies in the quality of the bag, then Bag Madness has to provide warranty. As sellers, it is their duty to tender goods that are free from any defects. And on the other hand, if the fault lies then on the buyer and her usage of it, instead of in the product, then Bag Madness is not entitled to provide warranty. Correct me if I'm wrong, but as I heard, Miss Natasha asked for the latest Chanel bag.
Yes, attorney, you're right.
And that is what the seller provided. If this is the case, then Article 1563 should be exercised. Let me elaborate on that. The buyer specified the bag she wanted. She defined the bag that she wanted and bought the bag of her choice. Miss Carla sold it without knowing how Miss Natasha would use it. The fault then lies on the buyer. Therefore, the seller has no duty to provide warranty.
Thank you very much for that, Attorney Manliguez. Alright, Ma'am Natasha, Ma'am Carla, do you think these answer your issue?
It certainly did to mine, RJ.
I suppose so. Okay.
Alright, it was the second day of February last month when a famous former child star used a beauty product that backfired. We have Hugo Batan for that story.
Miss Shana Alpasar was a famous child star in the early 2000s, but even with her high celebrity status, she isn't immune to being a victim of scams. Early this month, Miss Pasar used a beauty product she bought from an online store called Importante Buhi Cosmetics. Instead of making her skin look better, she claimed that her skin was swelled up after 3 hours of applying it. The management of the store where Miss Pasar bought the product claimed that they weren't aware of such defects, since it was carefully tested and most of the customers that bought it had satisfying results. This is Hugo Batan for HQ Mornings.
Fortunately, we still have attorney Manligas to enlighten us about this issue.
Hello everyone, a pleasant day to all of you.
Hello, attorney. We would like to consult you about this case. What should Ms. Pasar do about this matter? How can Importante Buhi Cosmetics prove their claim?
Well, this case surely fits Article 1566, wherein the vendor is responsible to the vendee for any hidden defaults or defects in the thing sold, even though he was not aware thereof. Although Importante Buhi Cosmetics can provide otherwise that they acted in good faith and in fact they were really unaware of the product's defects, basically, Importante Buhi shall pay any damages caused by their product to their customers unless they provide evidence of their claims.
There you have it, folks. Thank you so much for sharing your time with us, Attorney Manligas.
First, on our local news. A local face mask manufacturer, Silver Miss PH, has allegedly been selling masks with holes under the chin. The issue has been brought to light after Niall James posted on a Twitter complaint regarding the unnecessary feature of such masks. He said that there was no mention of the hole on their website, nor was it shown on the photos being advertised. He immediately messaged the company to demand for a refund, but the company hasn't been responding.
A face mask with a hole. Interesting, isn't it, RJ?
Interesting for sure, but is it safe? Is it just? To answer, we are honored to have our guest expert still with us, Attorney Denise Manligas, to give a legal commentary regarding the issue. Good morning, Attorney.
Good morning, Hans and RJ.
So, Attorney, what can you say regarding this issue?
For starters, the complaint is very relevant, of course, because we're on the course of fighting a pandemic. Just for the knowledge of everyone, health experts already posted an advisory against masks and other face coverings with holes. Since these allow the unfiltered breath to escape through the holes, it is deemed ineffective for fighting a virus such as COVID-19.
Yes, Attorney. I heard that a similar face mask, which has been heavily advertised by local artists, has already been declared by the DOH as impractical.
Surely business owners should be mindful of what they are selling to the people, especially in our situation right now. Profit shouldn't be the top priority.
Attorney, does our legal system have a say on this?
Actually, under Article 1561, a vendor shall be held responsible for warranty against hidden defects. The product is a face mask, which is for protection, but the hole in it makes it unfit for its intended use. So the defect is not only hidden, but also serious and has existed at the time of sale. Accordingly, it is apparent that Mr. James immediately notified the vendor, but there was no response. Thus, Mr. James has the right to elect the rescission of the contract or a reduction of the price with damages in either case. Such actions must be brought within 6 months from the delivery, since it is a thing and not a living animal.
Well, definitely an insight we can all appreciate. Thank you so much for your time, Attorney.
You're always welcome, Hans.
Now, let's dive into the entertainment realm.
First,
Next on our showbiz news, retired Mr. Ian Henderson decided to spend his quarantine building a barn. He decides to buy different kinds of animals. In a post he uploaded on Twitter, he was surprised by the legal processes needed just to buy a large cattle. According to Article 1581, the form of sale of large cattle shall be governed by special laws. The special law governing the sale of large cattle is Act Number 4117, now found in sections 511 to 536 of the Revised Administrative Code as amended, providing for the registration, branding, conveyance, and slaughter of large cattle. Moreover, the sale must appear in a public document. What's hot on the studio, Hans and RJ?
Stay tuned for more of the sizzling issues for this morning. We'll be back after these short messages.
Love, come on, let's just do it once.
Love? No, I don't want to.
Come on, love, let's play Mobile Legends just for one game.
Cut that out, babe. I have to study for Mamalaya's pre-midterm exam.
Whatever diversion it is, concentrate on your studies. You embrace a better future. A friendly reminder from the HQ Network.
Chismis, may TV si Mang Ben. Tama na ang chismis. Pag nag-toast, TV nagagamot. Alat na po ang gamutan, tutok sa pag-inom. Araw-araw. At healthy lifestyle, ipailan. Mag-dance everyday, kasi LC our way. Hala, ikalat ang balita. Si Mang Ben gumaling na. That's okay talaga. Ibalita sa iba. TVI Tultukan.
You're still watching HQ Mornings. We have another update.
Have you heard about the enticingly red case of Mr. Ko and Mr. Reyes?
Is that the one involving a red car?
Yes, but unfortunately we cannot interview them as of the moment due to some conflicts. But we have here the representative of Mr. Ko. Please welcome Attorney Castro.
It's good to see you, attorney.
It's an opportunity to be here. Good day, everyone.
Good day. May we know the background of the story, Attorney?
Of course. One day, my client, Mr. Ko, was intrigued about the car collection of Mr. Reyes. The latter then induced the former to choose among the cars since he was planning on selling some of them. Correspondingly, Mr. Ko chose the red car, to which Mr. Reyes agreed to sell. After the sale, Mr. Ko discovered that some interior of the parts had some defects, which may affect the performance of the car as well as the safety of the passengers upon usage.
Were the defects known, attorney?
The defects were hidden, unknown. Mr. Reyes doesn't know about the defects thereof, but still, he will be held liable for these defects.
How about Mr. Ko, Attorney?
Mr. Ko, on the other hand, may elect either to withdraw the contract or demand a proportionate reduction of the price with the right to damages in either case. The said provision is contained in Article 1567, of which the first alternative is known as Action Redhibitoria, while the second is known as Action Quanti Minoris.
Fair enough. I've actually heard about that, but I was not able to follow the next events.
The case actually went smoothly than expected.
Well, we're glad to know that, Attorney.
That means that the enticingly red is a case closed. Thank you for acknowledging our invitation, attorney.
No worries.
Next up, we have a case of lost products, which is a laptop and a TV. We have Lila Laborada for that story.
Mr. Tigugas also accidentally spilled hot coffee on his TV, which he already suspected had hidden defects while he was still using it. Eddie sa Puso Mo Gadgets and Appliances acknowledged that they were aware of these defects and were willing to take the responsibility. Now the question is, what can Mr. Tigugas recover from his laptop and TV? Lila J. Laborada, reporting live from HQ Morning.
As luck would have it, we have an expert that can illuminate us in Mr. Tigugas's case. Let's welcome Attorney Canyeda.
Thank you, Hans and RJ, for having me, and a pleasant day to all our viewers.
We are honored to have you on our show, Attorney Canyeda.
What can you say about Mr. Tigugas's case, Attorney? What can he recover from his laptop and TV?
So in this case, we can refer to Article 1568 to 1569. For his laptop, he can recover the price paid, the expenses of the contract, and the damages. Meanwhile, for his TV, he can demand for the price which he paid, less the value of his TV when he lost it. But since the company acted in bad faith, he can also receive damages from losing his TV.
That officially closes Mr. Tigugas' case, everyone. Thank you, Attorney Canyeda.
Yeah, I'm glad I could help. Have a nice day, everyone.
RJ, what's buzzing on social media today?
We're actually receiving a lot of tweets right now. I can see that our viewers are very intrigued by the topic that we are about to tackle. Don't forget to use the hashtag.
That's good. So in order for us to cater to those questions, let's welcome our guest speaker, or shall I say another expert, Attorney Morite.
Good day everyone, it's nice to be back here.
We are far more grateful to have you here again, Attorney Morite.
Well, I've heard that we have several viewers and participants today.
Absolutely. Will you do the honor of reading the first tweet, RJ?
Of course. Here's a tweet by Adits Me saying, in a judicial sale, will the person ordered by the court to sell his or her property be held liable if the property sold has damages?
It's a brilliant question. To start off, under Article 1570, where the preceding articles of this subsection shall be applicable to judicial sales, except that the judgment debtors shall not be liable for damages. So the preceding articles talked about the vendor or being held liable for the damages of the thing sold under certain prerequisites, and it may also be subject to specific exceptions and circumstances. So regarding the question, let us first learn what a judicial sale is. So it is the transfer of title and possession of a debtor's property to another in exchange for a price determined in proceedings that are conducted under a judgment or an order of the court. So in short, it is a sale of property authorized or required by a court of law. It is due in order to satisfy a debt of the judgment debtor. So, provisions regarding warranty still apply here, but since it is a judgment debtor who is only ordered by the court to sell the thing or object in order to satisfy its decision, then there can be no liability for the damages. So to answer your question, the judgment debtor will not be held liable for any damages and under a judicial sale.
As expected, what a great explanation, Attorney. But can I ask for a follow-up question?
Sure, go ahead.
What are the common instances that could lead to a judicial sale, Attorney?
It is typically ordered in instances of dispute where the property debt cannot be resolved or if the buyer is insolvent.
Okay, Attorney, thank you.
You're welcome. I really hope that I was able to give you an idea.
Undoubtedly. I've learned a lot, Attorney Morite. Do we have any other buzz out there?
Yes, we certainly have a lot of tweets here waiting to be replied to. Let us have them after a short break.
Troy Belisarios posted a photo with her dog Charleston last Tuesday. While it is a cute photo, the caption is a bit saddening. Troyan has left a heartwarming message for her dog Charleston, who has been recently diagnosed with benign prostatic hypertrophy. It is a condition which is an effect of sex hormones over time that can result to infertility. Fans left their sentiments on the comment section.
One of them said, "My new dog is also infertile. I have only known recently. She was being sold online by her former owner. Her infertility was mentioned in the post, but I wasn't able to read it because I only looked at the photos. I don't love her less. In fact, I love her even more. Besides, Article 1574 states that there is no warranty against hidden defects of animals sold as condemned or at fairs and public auctions. It is not, after all, a contagious disease, which is against the law as provided by Article 1575, which says that the sale of animals suffering from a contagious disease is void." Love you, Tryon.
That is all for our Showbiz Chica. Now let us look at our kapalaran with Kuya Toms.
Time check. It's way past 9 in the morning and you're still watching HQ Mornings. With the hashtag expert views with HQ Mornings, please keep the tweet coming.
And are you guys excited to meet our next expert?
I hope you are. Nevertheless, let's not keep you waiting. We still have with us on the show attorney Rick Morite.
Good morning, everyone. I'm glad to be here.
We are more than happy to have you here with us to answer the people's queries, attorney.
Well, to be honest, I am quite curious about the matter that I'm addressing today.
I guess you can't wait any longer, attorney. Well, we can't wait any longer to show you what's the tweet for today, too. Here it is.
Well, definitely you should take action. You could either choose whether you'll accept the bag even if it is a defect or maintain an action against the seller for damages. This action can be a rescission of the contract or a reduction of the purchase price. Depending on the circumstances, it can be under any of the 10 articles that precedes Article 1571. However, please bear in mind that the Article 1571 states that actions arising from the provisions of the preceding 10 articles shall be barred after 6 months from the delivery of the thing sold. So, this means that the action only prescribes 6 months starting from the date of delivery of the thing sold. Well, however, you can exercise your right only within the 6 months. If it is done beyond the prescribed period, then it shall be considered time barred.
Wow. Thank you for that, attorney. That will surely help our Twitter user with her problem.
Of course it would. It is Attorney Morite, after all.
Well, let's just hope that it would really help her.
We are certain about that, attorney.
Can't get enough, our dear viewers. Then stay tuned for more tweets coming up after a short break.
Feeling down? Fight back. Fight sadness with a healthy lifestyle. A friendly reminder from the HQ Network.
HQ Mornings is back with more sizzling news.
For our hashtag experts view with HQ News segment, where our viewers seek legal advice from the experts we have invited.
Here's a tweet from Twitter user @KayaPabah.
Dilek and I are best friends who recently bought a puppy and named it Paiman. Before Paiman arrived, the seller brought her to a vet clinic for a checkup and the results came out normal. However, on the second day since Paiman arrived, she started to exhibit symptoms of a neurological disease. The vet clinic we bought her to told us that Paiman's disease was caused by a genetic predisposition. In this case, what legal course of action should we take?
To answer that question, let's welcome another expert, Attorney Kate Luwag. Attorney, what can you say about the tweet of our Twitter user?
This situation is actually what Articles 1576-1577 covers. Firstly, there are certain kinds of genetic predisposition diseases which are undetectable until symptoms start appearing. So, you must first ask your veterinarian whether it is possible to detect the disease beforehand. Second, if the disease was detectable, then the veterinarian of your seller can be held liable for the damages. On the other hand, if the disease was undetectable, then this is what we call a redhibitory effect. You may take a redhibitory action based on the faults or defects of the animal within 40 days since the delivery date to you. But, please take note that this action can only be exercised with respect to the faults and defects which are determined by law or local custom.
Very enlightening inputs there, Attorney.
Now for a second tweet from Twitter user @Lisa2tatlo.
In line with the previous tweet, what if Paiman died on the third day from the delivery date? Will that be considered the responsibility of the seller?
Attorney, what's your say about that particular case?
This can actually be explained in Article 1578. The seller will only be held responsible for the death of the animal if he died within 3 days from the date of sale, not the date of delivery. The claim made by the buyer must also be based in the findings of an expert that the disease existed at the time of the contract. However, since Paiman died within 3 days after the delivery, the responsibility no longer falls on the seller.
Thank you for that insight. That was Attorney Kate Luwag.
We have more tweets coming in our #expert views with HQ News. Only here with HQ Mornings.
What do you think is the tweet for us today, RJ?
Well, we'll see for ourselves.
Okay, this is about my friend and my classmate. My classmate is selling cute little puppies and my friend who is a sucker for cute animals decided to buy one. As far as I can remember, they agreed to have it delivered on Wednesday afternoon. The day came and the delivery of the animal was successful. I don't know what really happened, but the contract sale between them has been rescinded. What do you think my friend should do?
To have an answer for that, may we call one of our experts? It's none other than Attorney Riri Vergara, the most talked about attorney of our time. Attorney, what could you say about our case here?
Happened between them can fall under Article 1579, wherein it states that if the sale be rescinded, the animal shall be returned in the condition in which it was sold and delivered, the vendee being answerable for any injury due to his negligence and not arising from redhibitory fault or defect. To make you guys understand what this article means, then I'll further explain it. Since the contract sale between the vendor and the vendee had been rescinded, then the animal that was received by the vendee will not be returned back to the vendor. In the case of returning, the animal, as mentioned in the article, should be returned in the condition in which it was sold and delivered. If it was delivered in perfect condition, then it shall be returned in perfect condition as well. However, if the animal is seen with any injury and it was due to the vendee's negligence, then the vendee is liable. On the other hand, if the injury arises from a redhibitory defect or fault, then the vendee is not held responsible.
What do you mean by a redhibitory effect, Attorney?
least a redhibitory defect. This is a defect that renders a thing useless or so diminishes its usefulness or value that it must be presumed the buyer would not have bought it or would have paid a lesser price if aware of the defect. And if a seller that knows of a redhibitory defect but omits to declare it, or that declares the thing to have a quality he or she knows it does not, is liable for the return of purchase price with interest and for damages and other expenses.
Wow, thank you for helping us understand, attorney.
It is crucial to have knowledge about that matter, so I am happy to share it with you.
Right. Thank you so much for that, attorney.
So did you guys listen to it clearly? I hope you do. It may help you if you have the same situation as them, or it could be of use in the future.
Do you guys want more? Let's welcome Mima for Fortune Telling with Mima.
Good evening, dear. I am Mima, the lucky star of your life. What's your name?
My name's Jacana. I'm here because I heard that your predictions come true.
So, do you want to know what your future holds?
Absolutely.
Now, give me your hand, and also 2 4-digit numbers.
I choose 1572 and 1573.
Alright, let's start. You will be lucky in a few days, my dear. You will be able to get a large amount of money to buy the 2 things that you've wanted for so long. But be careful of your surroundings for damages or defects. However, don't be disappointed with that thought, because I can see that you're a strong-willed girl and you know how to demand for what you truly deserve. If one of 2 things doesn't work, don't be afraid to have it replaced or compensated. Let me give you a scenario. You bought 2 Colorette products and you've only found out about the defect after you've paid for it. You can hold the seller accountable and ask for its warranty. But are the 2 things you want to buy animals?
Wow! You're so great at this, Mima. Yes, I want to buy 2 dogs with the money.
Small thing, dear. Anyway, that fortune won't apply only to the things that you really want, but your animals, right? It is also applicable to other things. As long as you're being alert and careful, then you're good to go.
I'll make sure to take note of everything, Mima. Here's my payment. Thank you so much for today.
Thank you as well, Chicana. I hope you can come back here real soon.
For our showbiz chica, actress and model Nadine Luster decided to try out putting her very own poultry farm as seen on her Instagram photos. On one interview with HK News, she shared her troubles in putting up the farm. She wanted to include eggs as one of the products in her poultry farm, and so she decided to buy 50 hens from Magnolia Chicken Incorporated. But it turned out that 25 out of the 50 hens were not able to lay eggs. And so, she filed a complaint against Magnolia Chicken Incorporated and asked for action quanti minors, as she is still willing to keep the hens despite not being able to lay eggs. In Article 1580, in the sale of animals with redhibitory defects, the vendee shall also enjoy the right mentioned in Article 1567. But he must make use thereof within the same period which he has been fixed for the exercise of the redhibitory action. These are the following alternative remedies of vendee in sale of animals. The vendee has the same right to bring on his option, either a redhibitory action or an action quanti minors. An action quanti minors is one brought for the reduction of the price of a thing sold, in consequence of defects in a thing which is the object of the sale.
Moreover, the action must be brought within 40 days from the date of the delivery of the animals to the vendee.
That's about it for this episode of the show.
We hope you learned and had fun as much as we did.
This has been Hans Saison.
And this has been RJ Milanes.
And you just watched HQ Mornings, making your mornings informative on home quarantine.
Remember to keep your eyes peeled and stay on the lookout. Have a great morning.